3, 2, 1, start. The submission made on behalf of the state that the above quoted clause 23 of the agreement is not an arbitration clause has to be accepted because exactly similar clause was held to be not an arbitration clause in the case of Bharat Bhushan Bansal versus UP Small Industries Corporation Limited AIR 1999 SC 899 Stop Para. Learned counsel for the state then argued that both the award and the decree having been passed on a reference under clause 23, which is not an arbitration clause, are liable to be set aside on that short ground. Stop para. We have heard the contractor appearing in person. Stop. It is not disputed that the sitting chief engineer, on reference of dispute in terms of clause 23, failed to decide the dispute. Therefore, an application under section 8 of the Act was made to the civil court to substitute him by an arbitrator. Stop. The record of the proceedings before the civil court, copies of which are before us, show that on the application seeking substitution of the arbitrator, the contractor and the state through their counsel were heard. Stop. Suggestion of names for new arbitrator were taken from the parties. Stop. The court on 14/3/1995 passed a consent order appointing Shri S.S. Mathur, retired additional chief engineer, as the sole arbitrator to adjudicate upon the disputes and decide the claims made by the contractor. Stop. The relevant part of the order of the civil court made on 14/3/1995 reads. Stop para. The advocates of the concerned parties have given their consent for appointment of Shri S.S. Mathur, retired additional chief engineer, Udaipur, as sole arbitrator. Stop. The advocate of the applicant has no objection. Stop para. Hence, the application of the applicant is accepted. Stop. Shri S.S. Mathur, retired additional chief engineer, Udaipur, is appointed arbitrator for deciding the dispute in accordance with the agreement number 75 of 77/78 executed between the parties. Stop. The arbitrator shall pass the award after hearing the parties in accordance with the provisions of the Act and the terms and conditions of the agreement. Stop para. The arbitrator be informed accordingly. Stop para. The sole arbitrator thus substituted on consent of parties conducted and concluded the arbitration proceedings. Stop. The state participated in the arbitration proceedings without any demur or protest. Stop para. We asked the learned counsel appearing for the state whether in their objection petition filed against the award under section 30 of the Act. Any objection on the competence of the substituted arbitrator to make the award in terms of clause 23 was raised. Stop. The copy of the application under section 30 of the Arbitration Act raising objection to the award filed by the state has been made part of record in these appeals. Stop. We have gone through the objection petition preferred under the said section 30 of the Act. Stop. We find that no objection was raised on the competence of the arbitrator or the validity of the arbitration proceedings under clause 23 of the agreement. Stop para. Clause 23 of the agreement is undoubtedly not an arbitration clause, and the sitting chief engineer, to whom earlier reference was made, could not have acted as an arbitrator and made the award. Stop. The sitting chief engineer, to whom initial reference was made, did not complete the arbitration proceedings. Stop. The substituted arbitrator was a retired chief engineer and parties agreed to his appointment and submitted to his jurisdiction. Stop. By consent of parties, he was chosen sole arbitrator and disputes were referred to him. Stop. The state, without demur or protest, submitted to the jurisdiction of the arbitrator and participated in the proceedings. Stop. The state is stopped on the doctrine of acquiescence and waiver from raising objection to the competence of the substituted arbitrator and validity of the arbitration proceedings by taking resorts to clause 23 of the agreement, on the basis of which initial reference was made to sitting chief engineer. Stop. See following observations in the case of Prasann Roy versus Kolkata Metropolitan Development Authority 1987 SCC 217. Stop para. The principle is that a party shall not be allowed to blow hot and cold simultaneously. Stop. Long participation and acquisitions in the proceedings preclude such a party from contending that the proceedings were without jurisdiction. Basically, the principle of waiver and estoppel is not only applicable where the award had been made but also where a party challenges the proceedings in which he participated. Stop para. Therefore, this appeal, CA number 8052 of 2001, preferred by the state, also deserves to be dismissed. Stop para. Civil appeal number 1400 of 2002, para. CA 1400 of 2002 has been preferred by the contractor, whereby its civil revision petition against the order granting 12% and not 18% future interest on the awarded sum under his application under section 152 CPC was dismissed. Stop. This court issued notice on the SLP and subsequently granted leave to appeal on a limited question as to why the decree drawn up in conformity with the order making award rule of the court should not direct payment of interest, pendant, light and future at the rate of 18% per annum. Stop.